I'm Jeremy Koop, former prosecutor, Kansan, and your dedicated defense attorney at the Koop Law Firm. The United States Constitution guarantees you the right to a jury trial in most criminal offenses. Today I'm going to talk to you about that process. Voir dire is the process by which a jury is selected from a panel of your peers. The prosecutor starts out and starts asking questions to that panel about their qualifications and what they might know about the case and how they feel about criminal law. Then the defense attorney does the same thing, talking to the panel of the peers about what they know about criminal law and what they might know about the case and their qualifications. After that's done, each side then is able to strike a certain number of jurors until they get down to the 12 jurors which are left on the panel of the peers. After jury selection, opening statements occur. The prosecutor goes first, and basically it's a roadmap or a storyline of what the prosecutor says his or her case is going to show. Then the defense attorney can present their roadmap through opening statement of what they say the case will show. After opening statements, the prosecution will start to present their case. And they will present their case by presenting witnesses who will testify and offering exhibits. After each witness has testified, the defense attorney then gets an opportunity to cross-examine each of those witnesses and call into question their stories. After the prosecution rests, after they've presented all of their case, the defense then has an opportunity to present evidence on their side of the story. One example of a witness that the prosecution might call is an eyewitness to the crime. And that eyewitness might say that the defendant did the alleged crime. Now the defense attorney has an opportunity after the eyewitness has testified to cross-examine and call into question the credibility of the claims of that eyewitness. So after the prosecution presents their case, the defense has an opportunity to present a case. And they can do that by way of calling witnesses to the stand or investigators to the stand that investigated on behalf of the defendant. Now every one of those witnesses is going to be cross-examined by the prosecutor as well to call into question the defense's version of events. Now it's the prosecution's job to prove their case beyond a reasonable doubt. That's the standard of proof. Now it's the defense's job to essentially chip away at that reasonable doubt standard to show why the state or prosecution or government has not proven their case beyond a reasonable doubt. That's the standard of proof that the judge will instruct the jury on before they go into deliberations. The judge will give instructions to the jury as far as the elements of the crimes that the defendant is accused of. And the jury will then take that packet of instructions back to the jury room and evaluate and analyze whether or not each one of those elements has been proven by the government beyond a reasonable doubt. That process of deliberation can take anywhere from minutes to hours or even days. A jury trial can be a long, complicated, and drawn-out process. If you're charged with a crime, you need a competent and aggressive criminal defense attorney. Contact the Koop Law Firm today, your dedicated criminal defense attorney.